People v. Leighton R.
Clara Hammond-Oakley from the Legal Aid Society on behalf of Leighton R. Your Honors, I would request 3 minutes for rebuttal.
Yep.
Thank you. This case presents an opportunity to reaffirm that in New York State, we do not allow the seizure of a person based on an uncorroborated accusation from an anonymous informant. The tipster here was a 911 caller who claimed that my client had just shot at him. However, there were numerous powerful indications that this tipster was unreliable and that his information was not credible, including that he refused to meet with police.
Did the lower court decide that there was a reasonable suspicion to stop the defendant, not only based on the tip, but also on the tint?
No, Your Honor, I don't believe that the lower court did do that, and I believe that this court's subsequent decision in People versus Nektolov forecloses that particular avenue. The officer at the hearing only testified that the windows were tinted. I don't believe he even said they were excessively tinted.
Well, I thought he issued a violation, I can't remember now. I thought he did cite him for the tint.
He believed that he had cited him for the tint, however, then he could not find any summons that was actually connected to the summons number that he had written down in his notebook. He never testified to the degree of the tint. He never testified that he was...
But is it a credibility decision? Let's say you're wrong, and the court did rely on both the statement by the officer that they had heard the radio run, or they got this information on the radio run, and they had an issue about the tint of the car. Is that, would that be enough in the record to support the stop?
I don't believe that that would be enough in the record under this court's recent decision, because the officer just stated his conclusion that the windows were tinted and didn't support any underlying facts supporting that conclusion.
No, I understand your point about that, but what if the judge thinks as a credibility determination that that is indeed what the officer subjectively believed, that the tint was excessive?
I mean, I don't think at that point that that's a credibility determination. There's simply not enough information in the record for the judge to make that conclusion. And I would also add that that's a claim that the prosecution seems to have abandoned at this point.
I'm sorry.
That
Are you saying
the
the
respondent
record-
seems to have abandoned at this point in the appeal.
Are you saying the record reflects that, or is unclear as to whether or not the defendant was actually issued a summons for excessively tinted windows?
Yes, because I believe the officer testified that he thought he had issued a summons, but then when he went into their computer system to look up that summons, there was no summons connected to the number that he had written down in his notebook.
Okay.
So he couldn't show that he had
Well,
actually
that means
issued
he might
that
not
summons.
have found it. That doesn't mean he didn't issue it. But I get your point about the record.
Yes.
Have you ever found any cases, or were you able to identify any cases where this court has found that reasonable suspicion couldn't be maintained when the caller was actually the victim of the crime? I know we have cases where we say, I've observed something, and we've said, look, we don't really know what the basis of knowledge is because they haven't identified what the basis of knowledge is. But in a case where the person calling is actually the one injured, like I've been shot, have we ever said that that's not enough for reasonable suspicion?
I don't think that that exact fact pattern has come up before. I think that this court has had several cases, like in Moore, where the caller said that there was a dispute involving men with a gun, where basis of knowledge wasn't specifically discussed. And it seems to me like the obvious basis of knowledge with that would be somebody seeing the dispute happening. I think that the reason that there hasn't been a case about somebody claiming to be a victim in particular is because this is a very unusual situation. Usually anonymous callers are people who are observing a crime from afar, who maybe are motivated to maintain their anonymity because they don't want to be involved with the case, maybe because they don't want a future defendant to have their name, their contact information, come after them.
You think that's different?
It doesn't make any sense here because
It may be unusual, but isn't it very different? To me, there's in terms of questioning the reliability of the information.
Yeah.
If a person calls and says, I see something illegal happening, I'm standing here on the corner, and I see something illegal happening across the street, as opposed to someone calling and saying, I just got shot, and here's a description of the people who shot me. And this is what they're driving, and this is the general area where you can find them.
Yes, it's very unusual because in that circumstance, the only person that that caller is trying to hide their identity from is the police, right? Because if my client had in fact shot at someone who he had beef with, who he had a grudge with, he would know who that person was. And then if the police were called and they said, we have a report that you shot, the person who you shot at called, my client would know who that person was. So under these circumstances, the only person that this caller is trying, if his claim is true, which I do not believe it is, but if it is true, the only person he's trying to hide his identity from is the police. And that is so that he can.
Let me just, so your position is they can't rely on that anonymous tip? Okay. What, if anything, should the officers have done? You get a call that there's someone who says, I have been shot. You've heard the rest of the detail
Yes.
about their description and so forth. What should the police do? Nothing?
Oh, no, the police definitely should have investigated this tip. They could have
And how
gone
would
to
they
the-
have done that?
They could have gone to the scene of this reported shooting, where in fact there was an
And let
officer.
potentially someone escape who's got a gun and is shooting?
No, because
people?
another officer could find this car and follow it, and they could have
Okay.
followed my client and seen if they made any observations that were consistent with my client having just been involved in a shooting.
What if,
What would-
what if
what
they,
would that
they
be?
get to a building, they park and they go in? Now what? What do you do?
I think that you are constantly getting information from the rest of the NYPD about whether or not there was actually a shooting.
And the victim doesn't want to be found?
The victim doesn't want to be found. There's no other indication that there was a shooting. You have an officer who's at this supposed shooting location looking around saying, there's nothing going on here, there's no shots fired here, there's no other witnesses coming up to me and saying, I heard shots.
So you're saying after the crime is over and the person calmly put their weapon in their car and they drive away, as long as they obey the traffic laws and every other law, there's nothing the police can do about it, even if an anonymous person says they're driving a green car, here's their license plate number, here's what the person looks like. They just get to drive away.
No, I think police can do everything, but they just can't go and seize that person who's being
What is
targeted by the
everything?
anonymous tipster. They can go to the scene, they can do investigation, they
What
can
if it's
follow
a
the car. And
felony,
in-
what if it's a felony drunk driving tip? They're going to follow them, and they're driving okay when they're following them, and they're investigating the bar they were in, and how much did they drink, and who is this person that called, and then suddenly they veer off and hit somebody on the sidewalk. Then they can arrest them.
I think that that example gets into California versus Navarrete.
That is
Which was a
Navarrete.
case, yes, which was a case where the U.S. Supreme Court discussed at length all of the
Well, there
special
again, it was a victim.
dangers.
Right?
That's true. It was a victim, somebody who said they were almost run off the road. And the U.S. Supreme Court discussed at length all of the special dangers of drunk driving.
But why is
Not
that so
firing a car
different?
and sticking a weapon in your glove compartment?
Because it's what is alleged, just based on this tipster's claim, is a personal dispute between two people that is over.
Involving
And the
a
tipster-
public shooting.
And the tipster does not allege that there's going to be any other violence. The tipster doesn't even say, quick, go get him. He's went that direction.
So now
You
we're
know,
supposed
he's
to
one
look at the
block away.
demeanor of the caller to make a determination if there's reasonable suspicion?
No, Your Honor, I do not think that you should look at the demeanor.
So
I think,
are you saying that the police need to follow the person and see if they make do another shooting of someone else?
no, Your Honor, because the information that can elevate something from a level 2 to a level 3
Yeah.
is conduct that might be innocent in other situations, but that when viewed in conjunction with the tip is suspicious.
Well,
So
I mean,
would-
but that's sort of what I'm struggling with. There's the tip that alleges a crime by the alleged victim, who may or may not actually be a victim, and information that is moments later, 30 seconds to 1 minute later, confirmed by the officer who observed people matching that description in the vehicle, matching that description at a location very close to, because although the person was a little cagey about who they were and where they were, they do know where the call came from, and that car was very close to where the call came from.
Yes.
So why isn't that the necessary confirmatory information that gives reliability and raises it to DeBoer 3 or reasonable
because-
suspicion?
Because this court has consistently said that there are two dangers to hearsay informants, anonymous or non-anonymous. There's two dangers. There's the danger that you have an informant who's well-meaning, but who is passing along not something that's not firsthand knowledge, is just suspicion,
So that's not
rumor,
that's not at
something
play
like that.
here.
That's not
That's not
this.
this case.
Right.
And the way that you deal with that fear, though, is that you require the tipster to claim personal knowledge.
Why
you
isn't the
know?
claim that I was shot personal knowledge?
That is personal knowledge,
Okay.
and that's why that prong of Aguilar-Spinelli,
Yeah.
or that very important factor in the totality of the circumstances, is completely satisfied in this case by all of that information. The fact that the tipster claimed he was a victim.
And the other-
fact that the car was right nearby. He had clearly probably seen my client, right, seen what car he
So
was
there
in.
are
What's
things to
missing?
corroborate.
So the other issue is that
So
the
there's the
other,
ability to corroborate.
the other requirement is the veracity
Is there an
requirement.
ability to corroborate the tipster so it's not just an empty call?
Sorry?
If you can corroborate the veracity
Yes.
of what the person has said. He says, I have personal knowledge,
Yes.
describes the car, tells you the location. So if you're able to corroborate the call, then why isn't it okay?
Because you're not corroborating anything having to do with the accusation.
So you have to
of a
have
crime.
criminality? You have to corroborate criminality?
I think you do have to corroborate the criminality, because otherwise you're letting the malevolent tipster.
But
that-
How does
corroborate-
gun? What about the gun? Does the gun corroborate the criminality?
If they had found the gun before the stop, certainly. But they found the gun at the
But
very
if you
end.
have a single criminal act that is completed, okay?
Yes.
And you have a tipster who calls in anonymously and says, I was shot, here's the coroner, here's the car, here's what they look like, then what corroboration of criminality beyond that do you need in your view? Is it that you need predictive criminality
No, I
going
don't.
forward?
I think predictive criminality is one
Okay.
kind of indicia. I think there are others.
So
I think the other.
What would
yes.
they be?
For example, in Moore, the corroboration required in Moore that was absent in Moore was that police officers showed up at the scene of this dispute involving two men with a gun just minutes after the call and looked around, and they saw a man fitting the exact description that the caller had given, but they did not see another man. They saw no dispute in progress.
Okay.
And so they said that the tip did not accurately portray the criminal.
But here then, I thought that they saw the car as described and the individuals as described shortly thereafter. I appreciate that they also, the officer on the scene didn't hear the shots, but they did see that, right?
Yes, and that's just like how in Moore they arrived and they saw the man with the red hat and the gray jacket and fitting that more complete description even than it was provided in this case.
What's missing here? What additional information in the tip would have been sufficient to satisfy the second prong in your view?
I think that what additional information needed to be corroborated by officers was they needed to corroborate to some degree that a shooting had actually occurred or that my client was just involved
So
in a
if,
shooting.
if instead of another officer who was on the scene, apparently right on the scene, had said, yes, there were shots fired, I didn't see where they came from, but yes, shots were fired in this vicinity, would that have been enough?
Yes, absolutely.
Can I ask one more question, Chief? Of course. I'm looking at Moore, and Moore says that the anonymous tip was received of a dispute involved a black male with a gun described as approximately 18 years of age, wearing a gray jacket and a red hat. To me, that's very different, because there's no information there concerning the basis of knowledge of that person. They're just calling up saying dispute, male black, and a description. That's very different than here, where they're saying, I've been shot.
I think it's different in one aspect, which is that the court didn't discuss the exact words used by the caller in reporting this dispute. It's very possible, though, that the caller said, I'm looking out my window, there's two guys out there fighting, one of them just
But we
pulled
don't
up a
have
gun."
that information.
And that wasn't, because the main issue in Moore was the anonymity, that we had this anonymous tipster who could have been fabricating an allegation of criminal activity out of whole cloth while seeding it with easily observable details that they could see out
Right,
their
and they're not giving a
window.
basis of knowledge for that information, where I find this case very different.
I think that the issue in Moore was both potentially basis of knowledge, but obviously veracity. And in my case, we also have veracity, and we have simply nothing that demonstrates that this tipster was telling the truth about the accusation of a shooting.
I don't understand what other information there would be. And predictive information when a crime is over is nonsensical in my mind.
I think that the other information there would be that officer who was posted at the exact intersection that the caller gave.
So if there's
saying-
no officer on the scene to say, yes, I heard a shot, or no, I'm not aware of a shot, that's it. You're never going to get enough veracity, indicia of veracity, to be able to make that stop when you see the people matching the description.
No, because the police can do other things in the meantime to try to get from that level of, I'm at the scene, I have this report, I'm looking
But
around.
meanwhile, the car is driving away, which might have folks in it who have just engaged in a shooting, and we don't know what they're going to do next.
But police officers can follow that car, and if they do anything illegal, then the police officer will have personally observed that and can pull them over. And illegal down to the level of weaving in and out of traffic.
So the police follow,
Yes.
and they say, I see, they didn't put on their light to make that right turn. I can stop them. Why is that more of a basis than
I don't think-
someone actually calling and saying, I was shot, here's who shot me, here's the direction they're going in, and they're in the following type of vehicle?
Because we've decided that the police can pull people over for traffic infractions.
Because they've observed it themselves?
Yeah, and that's a reliable police officer who we trust saying, I just observed them break the traffic law, whereas in the other instance, it's a unaccountable, unidentified caller.
But the officer's testimony about the tint, not reliable.
No, because he didn't provide any facts supporting his conclusion that the windows were
In your
unlawfully
view, would the
tinted.
Navarrete facts, which they analyzed under Gates, would they pass Aguilar-Spinelli? Here's what
That's a
they
good
said.
question.
Showing southbound Highway 1 at mile marker 88, silver Ford 150 pickup, plate number, ran the reporting party off the roadway and was last seen approximately 5 minutes ago.
I do not believe that those facts would satisfy Aguilar-Spinelli.
It lacks the veracity element, doesn't
It
it?
lacks the veracity element, yes. And I think that that's part of why some courts have interpreted Navarrete as specifically applying to drunk driving cases,
So-
because it is so hard to imagine how to satisfy that
If we
veracity
agree with
element.
you, Aguilar-Spinelli applies, and that it doesn't meet it, and we get Navarrete in New York, the officer would have to follow the person who ran that person off the road, allegedly.
I think that if you agree with me and apply this rule, there might be exceptions to the rule. I think that, even in JL, the court described potential exceptions, and La Pena, this court described potential exceptions.
Exceptions
However,
based on
this-
public safety?
I would leave that to future courts, but I think, the example given in JL was, what if somebody, anonymous caller calls and says that somebody has a bomb? I think that there could be a situation like that. I think that is not
And we'd have to
this
draw a
case.
line then between somebody has a loaded gun and just used it and somebody has a bomb.
Yes, and I
Or-
think
Or
that,
someone has a loaded gun, they just used it, and they're continuing to shoot. They're driving down, I don't know, pick a street, Broadway, and they're shooting up the street.
yes, which I would add would be very unusual to only get one single anonymous call about. And so I think that that's why,
Let's go with this, say you do, but by the time the police officers get there, there's not shooting up the street, right?
yes.
Right, they don't
However,
observe them, because if they observed them,
if they
or
observe
heard
them.
them, or some other officer heard them, you're saying that would have been enough.
Yes, certainly.
Thank you.
Thank you.
Good afternoon, ADA Nicole Nichols for the Office of Darcel D. Clark. May it please the court. I believe counsel's argument today here, maybe I misunderstood it, seems to be that she's accepting that the personal observation, that the person saying, I called, satisfies the basis of knowledge prong, but she's now saying that we need confirmation for the veracity that goes to the criminality. And this court has never held that.
Well, that's the two-prong test.
Yes.
That's
but-
her argument. Your argument is that somehow, as I understood your briefing, you'll correct me if I'm wrong, that somehow those two prongs collapse when it's a victim. But I have a question for you.
Yes.
Anybody can call and say, I just got shot.
Yes.
Anybody.
Certainly, Your Honor. And we acknowledge that that is a concern. What we would say is that the answer to that concern is not constraining the police officers from being able to conduct timely
No,
investigations
the
of
question is not
credible
about
claim.
constraint or not constraint, it's about the rights of the individual. That's what we're talking about.
No, but the rights
Not
of the
the,
individual.
not the caller, obviously.
No, no, no.
We're talking about the
But what
potential
we'd say is
defendant.
the rights of the individual is balanced, right, against the law enforcement's
How
need
so?
to act.
How
sorry?
do you balance those rights?
Well, I think we look at here that what information did the officer have, right? He has a call saying there's been a shooting, not just that somebody has a gun, but somebody just shot, that there's an injured citizen, and that they're fleeing in a car, a white Mercedes with two individuals.
If there had not been the allegation that he had been shot, would it be sufficient in your view?
I mean, I think it would be weaker, because if, not, well, that
So
he
what
had been
is
shot
it-
at? If he had, I think if he
No,
still
no.
said he has been shot at.
Yes, they shot at me and they barely missed me.
Right.
They shot at me and they got me.
Right.
Still, I think in both cases, a claim of being a victim. So
Right.
what is it about that particular claim that means that the police don't really have to look further?
Well, we're not saying, Your Honor, that it makes it per se, right?
No,
what
but I
we're
do think you're suggesting it weighs heavily. So
Yes.
why is that? I mean, I suppose someone could, just as you know, an anonymous tipster could make up any allegations, and that's what drives the concern, right? An anonymous tipster could do the same about a claim that they were shot or shot at or something like that. So why is it particularly credible in your view?
Well, what we're saying, Your Honor, in these situations, reasonable suspicion, probable cause,
Yeah.
it's not about certainty. It's about probabilities, right? Is it more possible that where you have an information of somebody saying, I have been personally injured, I have,
But I'm just trying to grapple with why that is the case in your view. Is it because we think that we can't quite imagine somebody would make that up? Is there something else about it? What gives it resonance for you?
I don't think, I think the idea is the court looks at that basic of knowledge problem. They say, can we say, without more, can we say where somebody is speaking on personal knowledge, it's more likely that what they are saying may be
But
true.
if the assertion that they're making is that they have been shot,
Right.
it does seem to beg the question of why are you unwilling to say who you are? Why are you unwilling to assist the police in getting you medical attention? Why are you not responding to the police? It does put in question the veracity of the assertion, no?
It certainly does, Your Honor. But here, there are many reasons why somebody might not, even a victim, may not want to come forward.
But
We
there are
don't
other
know.
aspects of the record regarding the exchange about being shot that don't make a lot of sense, right? He says he's going to the hospital, then he says that, there's no record that he actually goes to the hospital. There's a lot of back and forth, which, from the record, raises a lot more questions than it answers from one read.
Well, we would say it
Plus,
raises questions after the
he
fact.
seems to know who the person is, but doesn't give the name.
That is true, but he doesn't give a name. The fact that he knows the exact
He
address
says he doesn't know his
suggests he
phone
does.
number.
He doesn't know his own phone number.
Yeah, that's a unusual response.
But I think he's given, Your Honor, that I've been shot, he's given his location for where he's shot. His
He
location is
actually gave two
confirmed, is
different, didn't he give
corroborated.
two different locations about where the shooting was, one in the first call and one in the second?
But I think for the stop, we have to look at the first call,
Well,
right?
to
That's
say he's-
subsequent information, Your Honor.
To say he's giving his location is a little bit misleading, I think, because what he's really giving is the location of where the police can find the people who he's fingering for the act.
But he's there, Your Honor. The
Well,
911
he said he
call
was there,
placed-
and it turns out that later on that was roughly confirmed, that he was in the area. But, I think it's very important, especially for your argument in this case, that we only look at what the police knew at the moment, right? Not what they learned after the fact. And in that regard, it seems to me like the information that he was providing wasn't necessarily to confirm his identity or to bolster his veracity or anything like that. It was to let the police know where they could find the people who he says committed the crime?
I think the first thing he said is, "I've been shot." As we look at the call, and we listen to the things that he said, I think he wants to he's expressing the nature of the crime that has occurred.
He wants to aid? I mean.
Well, no, I said no, I didn't say, I said he expressing, telling them what has occurred, what is the crime.
Yeah.
I've been shot at. And yes, he's focused on making sure they catch the person, but that's, I think any victim might be, concerned about making sure the person's
Don't you think some of these
caught.
facts really cut against his credibility? That is, he
Sorry?
says, don't many of the things he says cut against his credibility? That is, he says, I've been shot, but I don't want an ambulance. I've been shot, but I don't want to go to the hospital. I've been shot, now I'm getting into an Uber and going to a hospital. I've been shot, I don't know my own phone number, but I know the street address of the person who shot me, but I'm not telling you the name of them. All this makes it seem as if this is fabricated for the purpose of getting the police to go stop that car and get the gun.
Ending with, I was shot in Mount Vernon.
Well, as you said, the Mount Vernon comes afterwards. But, Your Honor, the question is, should the officers have investigated this call? Is there enough here that a reasonable person getting that information have investigated?
She's not even taking the position that you don't investigate. That was one of the first questions I asked.
Yes.
The question is whether or not the investigation in this case, under these facts, given what the officers knew and what the tipster said, lawfully can include a stop. That's the question.
And we believe it can, that there's enough here that a reasonable officer getting such a call from a said person that's a victim, and then he corroborates within 30 seconds, Your Honor, 30 seconds to a minute. He sees the car leaving from the location that he believes the shooting happened. And,
So
what
is
for
the
stuff that happened?
timing that the car is seen a cooperating factor?
Yes, we believe that the contemporaneous nature from the time of the call to seeing the car, seeing that it has the two occupants, that certainly aids in the veracity of the officer being able to credit the
But that is also
call.
true of an anonymous tipster who is fabricating, right? Of course, they're going to tell you where you're going to find them.
Right.
And they're going to do it. They're there right now. You can go there right now and you will find them.
Again, Your Honor, as we said, the answer to that fabricating or that person is not to constrain officers, to stop them from engaging in necessary investigations of ongoing or a recent
But
criminality.
again, no one's saying
a
they can't
recent criminality.
investigate. I mean, I think she's arguing, yes, do a full investigation, please, but the question is whether or not that can include, under these facts,
Right, and I think-
stopping the driver, stopping that car.
I think Your Honor asked her, what should the police have done?
Right.
And our position is, what they did here is what they should have done.
Counsel,
That the police
To go back to your opening statement, let's assume your characterization of your adversary's argument is correct, and that she conceded, and, she framed it in the rubric of Aguilar-Spinelli. She conceded reliability, but she said what the problem here is, it's the second prong that's missing, the veracity. Do you agree, I think I know where you stand on the applicability of Aguilar-Spinelli, but if Aguilar-Spinelli was in play here, do you agree that there's a problem with veracity? And if not, what is the evidence that bolsters the veracity prong?
No, I would say there's no problem with the veracity. That we've never required corroboration of the veracity from criminality. My understanding is you either have personal observation, or when there's no personal observation, then you require corroboration of the criminality. But that goes to the basis of knowledge prong.
So I just want to be clear. I go get a burner phone. I know what Judge Canataro looks like. I know what kind of car he drives. I know his license plate number, and I know on Friday when he's going to be leaving court. And 2 minutes after that, I call and say, here's what you got to look for. I don't actually know his home phone number, so maybe I don't provide that. But I assume from your point of view, that doesn't actually make a difference,
In terms of,
the lack of the phone number.
correct. I think,
So is that what we want the police to do, to stop Judge Canataro because I make a phony call? Oh, when I say I've been shot.
I think the reasonableness of the officer's
He's got no
conduct-
gun in the car, so his rights are violated, but that's the end of it.
No, No, but Your Honor, it would be a brief investigatory stop. The officer here intended, he believed there was a victim a block away. He intended to just get him to come
Presumably, the Albany
and
police
do-
officer would believe me, too.
And we would say that it's reasonable for the officer to make that.
Well, this wasn't a
belief.
brief investigatory stop. This is a stop that culminated in an arrest because of what happened. But the question we have to decide is, was the intrusion ab initio justified?
And we argue it was, that under the totality of the circumstances test, it certainly was. Under Aguilar Spinelli, it was. It may not have risen to the level that of a probable cause,
Oh, I
but there's enough here
forgot to
for
add that also Judge Canataro and I disagreed on some case on Thursday, and so I said that I had a beef with him.
We have beef.
But
We have beef.
What I would just say, Your
We're old
Honor,
enough that it's a beef, by the
we
way.
want, I'm old enough to know beef. We definitely want officers to have the flexibility to engage in the type of investigation that happened here. Under my colleague's theory, the officers here should have let this car continue going.
Do you agree if the person had just, if the tipster had just called and said there was a shooting, that would have provided the legal basis for the stop? Not said, I've been shot.
Again, that would be, we would need some more facts, I think, for me to say that. If it just says there's a shooting and we don't know the basis of that knowledge, there's nothing, and that's where they would say, if you don't say, I've optimally saw
I
it,"
just saw a shooting
okay, and then.
by
and
someone, two men, black man in a white Mercedes driving on whatever street.
Then I will say it's enough. He says, I have just seen a shooting. We have that personal observation that the officer can credit and act appropriately on that. And so,
Well, then it's quite the heyday for anyone who wants to fabricate.
again, Your Honor, as I said, that is a concern. Even under Aguilar Spinelli, there would be a concern about a fraudulent tipster.
Well,
that
that's
there's
why
no
the
way to
test
protect against.
exists, right? It exists because of that concern.
But it does
Certainly,
not-
we've said these are the most suspicious grounds, are when you have an anonymous tip. We're not talking about a tip from someone that's known, right? It's the anonymity of it. And in
Oh.
this case, I don't know how much more obvious it could be that the gentleman wishes to remain anonymous.
There are reasons for that, Your Honor. But, I mean, here, we of course argue on appeal that this caller is an identifiable caller, that he's not really anonymous.
He's
but
identifiable? I thought they tried to find him and couldn't.
I think we would present that if the police really wanted to, given the fact that they had
He
his phone number.
didn't really want to, although
I
the
don't-
officer described several attempts?
I think after, in terms of, for the shooting, but after the fact that they realized they had the gun possession and a decision probably was made to just proceed on that
But
prosecution.
the caller
and
is
the other.
unidentified in the record, right?
I'm sorry?
There's no indication in the record that we know who the caller was.
Well, we have a name and we have a phone number, and I think if truly we had wanted to, that other investigative steps could have been taken with that information, that could have yielded the actual identity.
You
But-
wouldn't want to find the victim, to have them potentially testify?
I mean, as you said, after the fact, it became clear that this is an
Well, I mean,
individual that does
isn't
not
this,
want
isn't
to
this
participate.
argument, of course, the descendant of it that took to task the majority on this, isn't this argument that we don't have to worry about these anonymous tipsters because you can actually find them?
Right. And as I said, I believe the record
But
isn't
isn't
clear.
the opportunity to be able to find them is that you might actually go and try and find them?
No, I think the record isn't clear as to at what point did we say, you know what, we're going to abandon the shooting call because we found a gun. We're just going to go forward on the gun possession. And
Instead of an attempted murder charge.
where you have a victim that apparently is not, is not willing to come forward, and there may be various reasons for that. Valid, that has nothing to do.
So they're
Your red light-
honoring the victim's wishes not to be involved when they could have an attempted murder charge?
Your Honor, I think the question is whether the police had information here about a shooting that has happened on the street at the time of the stop, which was in close proximity.
Your
They do not
red
know
light is on.
what's happening.
Could you just, maybe for one or two sentences, address the search of the car?
Oh,
The
definitely,
search of the
Your
glove
Honor.
compartment.
So we would say the search of the car was permissible. There was consent to search for the search. defendant told, without being asked, the defendant told the officer, you can check the car. Check in the car.
About the locked box.
Well, it's twofold. We say the consent would include the glove compartment. At the time the officer goes to check, he doesn't know that this is locked, right? And we would say he can certainly pull on it and look to see if it's open. Once he pulls on it, he says it creates a gap, and through that, he both saw a gun and smelled the distinctive odor of gunpowder. At that point, we say the officer had given.
So it's not consent to go into the locked glove compartment. It's because within that scope of consent, he can try and open it, and if it's open, go in, and when he does that, it is locked, but he then says, well, there was a gap, I could see, and I could smell the gunpowder. I saw the gun, I could smell the gunpowder.
Right.
And it's that observation that then allows him to take the key and open it? And take possession of the gun?
Yes, and those were affirmed findings, Your Honor, that the suppression court credited the officer's testimony and credited the fact that when he attempted to open the glove compartment, that
Created a
crack.
gap.
So
it
that's
created a
beyond
gap.
our review, is what you're saying?
Yes, and we would say that those things could give us probable cause for the search, and we would ask this court to affirm.
Thank you.
Thank you.
So, Your Honor, if I could begin, respondent says that the answer to the fear of fabrication is not to constrain the police. That's the only response to the fear of fabrication. That's what this court did in DeFalco when it set out very strict rules for relying on even a known informant's information. And that's what you need to do if you want to prevent reliance on anonymous informants or otherwise potentially malevolent, dishonest informants at the reasonable cause standard too. You need to say that even when the police have certain information, that is not necessarily enough for them to go and do an intrusive stop as a result of it. I would also like to briefly address the identifiable issue. I think that the respondent is giving very short shrift to the NYPD in this case, which is not something I'm usually arguing for. This officer testified that he called this phone number for days, multiple times a day. He testified that he called hospitals in all of New York City, all the boroughs, I believe maybe not Staten Island, but he said all of New York City and also Yonkers to look for this person. They were trying to find this person. They wanted to speak with them to see if they could make out more than just mere weapon possession, especially because they actually had two people in that car. And the gun was found in a locked glove compartment. This was not my client's car. And so they had a strong motivation to find this person who could corroborate further a allegation of gun possession. I would also like to talk about the search, but if I could just briefly discuss the importance of personal observations here. I have certainly conceded that this tipster said that he had a personal basis for his knowledge. His personal observation. The issue is that under respondents' sort of quasi-Aguilar-Spinelli test or their totality of the circumstances test, they're saying that that's all that matters. But that's not all that matters. This court has said repeatedly that we also have to have something to show that the accusation is truthful. And we have nothing to show that that claim of a crime is a truthful claim. As to the search, Your Honor, at the time that this police officer was in the car, in front of the glove compartment, the reliability of this tip had had the rug pulled out from underneath it. At this point, what the officer had a report of was a shooting. He didn't have any location for it, other than that it was somewhere in Mount Vernon. He didn't have any time for it, other than that it was at some point prior to the call. And the caller also at that point had refused to give his name, refused to give his current location.
And do you think that's unusual, that somebody that's shot, let's say, in a drug deal gone bad or in a gang war, do you think it's unusual that they call the police and say, look, I've been shot, I'm not giving you my name, I'm not telling you where I live, I'm not telling you anything, this is who did it? Like, what's your basis of knowledge for saying that that's unusual?
If it's not unusual, then I think that it would certainly be unusual for the police to then go and take the kind of intrusive seizure action that they did in this case. Instead, that kind of tip should be treated like what it is, which is a lead for police to investigate further. And they can then go look and try to see, did the shooting happen? Are there other witnesses? Are there videos? Like, what else can we bring into this to prove this case? Because even if they go and find the subject of the tip, even if they go and arrest the subject of the tip, they don't have a
But it's
case
not
at that
a lead.
point.
It's not suspicion of criminal activity. It's a report of a criminal act that has taken place. It has to be something more than a lead. And I get we're struggling to figure out exactly where it fits on the spectrum, but it's a report of a crime that we all agree that the police have to act on.
Yes. And I would direct your Honor's attention to People versus Benjamin, which discusses this, which is that when the police get a tip, they are duty-bound to investigate it. They can go to the scene, and at that point, they look around and see, is there anything here that lines up with that report of criminality? In People versus Benjamin, it was seeing somebody in a crowd of people that they had gotten a call that people had guns, reaching behind his waistband, which the court said was a telltale sign of gun possession. These kinds of tips can bring the officers to the scene. They could have gone to my client's house, the address that the tipster gave. They could have gone to the scene of the reported shooting. They could have followed the car. It just limits them from taking that additional intrusive step of stopping my client's car.
Thank you.
Thank you.